Oh, okay. Good morning, everybody.
Good
Um,
morning, sir.
oh, good. I was just going to say that can somebody do a sound check that you can hear me, so at least you can hear me. I'd been speaking to myself for like 10 seconds, not realizing that I was still muted. Um, so thank you very much, everybody, for joining the class. Let me start by saying that Dr. Folari told me that he had actually dealt with capacity. That I was scheduled to start with creation of agency. So today we're going to be talking about um, creation of agency. We have understood the concept of agency and in very, very simplistic terms. It's a relationship between a principal and somebody that either he's given express or implied authority, and in some cases where estoppel applies, to enter into binding contractual relationship or relationships between the agent and the principal. So that's the basic sort of concept of agency, which is that a person can act in another person's stead and indeed create binding contractual relationships with third parties. Of course, you will see when we go through the different ways that agency can be created, that there are also guardrails within that relationship. So how do you create an agency relationship between the principal and the agent? And there are four broad ways by which an agency relationship can be created. And two of them, basically, one would say is done with the knowledge of at least the principal, the person who primarily should be responsible for the contractual relationship. And then you will see two where in one of them, it is not so much what the principal intended, but that the law reviews the conduct of that principal and then says that because of the conduct of the principal, he is estopped from saying that there is no agency relationship. And then finally, we look at how agency relationships can be created by operation of law. So irrespective of the intentions, but given the special or exceptional circumstances at the time, you could have an agency by necessity that we'll talk about, or also the situation of a husband and wife. And I'm sure that that will be an interesting conversation in terms of contemporary times and marriage relationships and the dynamics of marriage relationships in the contemporary world. Don't let me just say Nigeria, but all over the world. And you see that most of the cases that evolved on this point are quite old cases. And the correctness or the current appropriateness of these principles, as far as I know, have not now really been tested. But you see the point that I'm trying to make. So we have four basic ways by which an agency relationship can be created. The first one is by agreement, and it could be expressed or implied. The second one is by ratification. The third one is by estoppel. And lastly, as I said earlier, by operation of law. Now, as a starting point, I sort of refer us to a Supreme Court dicta, which again, in describing the agency relationship, sort of points to the ways in which an agency relationship can arise. And that's the case of Pascuto against Adecentro Nigeria Limited. I just listen to what the Supreme Court says in that case. The relationship of principal and agent may arise by express appointment, by virtue of the doctrine of estoppel, by subsequent ratification by the principal of a contract made on his behalf without any authorization from him, and we'll talk about that, by implication of law in cases where it is urgently necessary that a person should act on behalf of another, and by presumption of law in the case of cohabitation. So you can see that the Supreme Court sort of just captured all the different instances in which an agency relationship can be created, either voluntarily and in some exceptional cases, involuntarily. But if you start with by agreement, I mean, perhaps this is the most obvious way of creating an agency relationship. We know that for somebody to be put in another person's stead, and in such a way that that person can create binding legal relations on that other party, there must be some kind of understanding, or if you like, agreement between those two parties about the nature of the agency relationship that they seek to create, the duties of such an agent, particularly where the parties want to impose additional duties over and above what I call the implied duties that we'll be dealing with later on. And so agreement, obviously, is the most common mode of creating an agency relationship. And essentially, the agent and the principal would agree that the agent acts on behalf of the principal in creating contractual relationships between the principal and third parties, or in the disposition of properties. And we'll talk about that briefly when we talk about issues around powers of attorney. So the agreement, as you can imagine, can be reached expressly, and it could be in writing, or it could be in writing or impliedly. And therefore, we have the express or implied creation of agency. Now, on the point about express agreement, as you can imagine, it is always important, particularly on the point of evidence, that whatever agreements between the principal and the agent is preferably to be in writing, so that all the terms and the conditions are clearly stated in black and white, and all our basic principles of contract, particularly the point about consensus ad idem, would be clear to anybody that is in that relationship. But there's always some point that is made, some nuance that is made between a consensual agency and a contractual agency. Because in the case of the contractual agency, which has consent underpinning it, obviously, there are issues about remuneration of the agent, the scope of the duties of the agent. But there are instances in which an individual can consent to be an agent without earning a commission or obtaining any form of consideration from the principal. And that's typically a gratuitous agency relationship. And that is also perfectly okay for as long as the agent fully understands and accepts that the relationship is primarily on a gratuitous basis. So that's the slight between a contractual agency and a consensual agency. You can have a consensual agency without an underpinning contractual arrangement. But in the case where you have an underpinning contractual arrangement, of course, consent such a relationship. So as you can imagine, where you have an express agreement to create an agency, the ordinary principles of law of contracts would apply, and the parties must consent freely to creating the relationship. Their minds must be at idem, and of course, all those vitiating elements in contract must not be present. No fraud, no duress, no misrepresentation, no mistake of fact. And really, just with any kind of contract, there is really no particular form that is required for the creation of an express agency agreement. So it could be oral, it could be in writing, it could be under seal. And we'll talk about one of the agency relationships that must be under seal for it to be effective. But as I said earlier, it is always advisable for certainty that your agreement should be in writing. Now, in terms of some agency relationships that require more than just being in writing, you have instances of a power of attorney that is given to an agent, and it's most common in the area of disposition of property, disposition of land. So, for example, you're living in Nigeria, you own a 4-bedroom house in Ikeja, and then you decide to emigrate abroad, Japa, and you don't want to leave your 4-bedroom house without anything. It's an asset that if you're not living there as your home, you want it to yield some return for you. Otherwise, it will be a wasting asset. It will just start deteriorating if nobody lives in the house. So you decide to get your friend or your cousin or whatever to help you manage the property, help you get tenants into the property, help you sell the property, for example. If you decide that, oh, in fact, I need the money from this property to settle my family in Canada, so I need the cash. So sell this property for me, but I have to leave. I can't finish the transaction before I leave. Then you give somebody the property. Those are the sort of more common ways in which you use a power of attorney. And that document generally must be under seal. So for example, we refer there to Section 78 of the Property and Conveyancing Law that is applicable in Western Nigeria, and Section 78 there that provides that an agent could not create or dispose of an interest in land or dispose of an equitable interest unless he has been appointed in writing. There are also other instances in which the power of attorney can be used. And again, in that context, it has to be under seal. So there are also instances in which maybe some people have not really perfected their title to land and they want to sell off the land, and to avoid all the rigmarole of trying to go through perfection and the costs and everything, they can give a power of attorney to the potential buyer, which gives him authority to deal with that property in any way and manner in which the buyer deems fit. And such powers of attorney are regarded as a power of attorney coupled with an interest, and they are irrevocable, unlike the general principles of agencies that you can terminate at any time. So that's the sort of express agreement for the creation of an agency relationship. And as I said, if it is in writing, I can say virtual hand. If it is a question, can we wait till the end? But if it is not, then what is it about? Okay. So in terms of an express agreement, the truth of the matter, or the fact of the matter, is that sometimes parties cannot, and in fact do not, expressly agree an agency relationship, although they intend to make such relationships. And in certain instances, the courts then have to infer an agency relationship from the conduct of the parties. So if for example, the parties have by their conduct consented to a particular state of affairs, which is explicable only in terms of an agency relationship, then the courts will infer an agency relationship in such circumstances. And the issue as a matter of law is whether there is a clear distinction between an implied agency and agency by estoppel. And what I will say is that the circumstances in which the question of implied agency would really occur relates more to the scope of authority than to the existence of the agency. And that is what makes the distinction between implied agency and agency by estoppel, where it is as a result of the conduct, particularly of the principal, that has led to some people changing their position, that there is then an agency by estoppel. So that's the sort of distinction between the implied agency and the agency by estoppel. So putting aside the sort of ex ante creation of agency, and what I mean is that the agency relationship is created and then the agent begins to act pursuant to that express or implied agreement to act as an agent. So essentially, the principal confers authority on the agent before the agent acts, which is the critical point here in drawing a distinction with agency by ratification. So there are instances in which, rather than an ex ante authority to act as an agent, you have an ex post ratification of what the agent has done by the principal. So in ratification, ordinarily, what is done on behalf of the principal is done when the principal and agent relationship does not exist. So the agent had no authority to do what he did at the time. But it so happens that after the act, the principal, that is the person on whose behalf the act was done, then accepts it and adopts it. And that is what we call agency by ratification. Because if the act is not ratified, then the agent will have acted without authority. Or there are instances in which it is not so much that the agent did not have authority, but rather that the agent exceeded the authority that was given. And that also requires ratification. And that is an extremely important point in the context of somebody who has acted without authority and somebody who has acted ultra vires, that is beyond the scope and remit of his or authority. But in either case, whether the person acted without authority or acted beyond authority, once ratification is duly made by the principal, then that ratification itself puts the parties in the same position they would have been, assuming that the agent had the ex ante authority to act in the first place. However, ratification need not take any particular form. In most cases, any act or statement from the principal, which clearly shows an intention to adopt, would be regarded as sufficient, even for a written contract. However, if the contract was made by deed, then the ratification should also be made by deed. And I cited that very old case of Oxford Corporation against Crow. But ratification has some specific requirements for it to be recognized. And the first one is that the agent must have contracted expressly as an agent for the principal. So it must not be a case of an agent who had acted on its own behalf for him or herself, and then later on tries to now say that, oh, the principal should ratify. So the agent clearly must expressly act as an agent from the get-go. And there are two authorities there that you can look at, particularly the Folashade against Drew Shola Nigerian authority. Now, at the time that the agent purportedly either entered into a contract on behalf of the principal with a third party, the principal must have been in existence at that time, because an agent cannot enter into contractual relationship on behalf of a principal that was not existent at the time of the formation of the contract. Now, this is an important principle of common law. But this principle of common law in the context of company law has now changed as a matter of statute. But before I address that point, and you can see the underlying reasoning here, which is that how can somebody who is not yet in existence be made party to a contract or be made bound by a contract? Remember your privity of contract. So if the principal was not in existence and the agent is purporting to act on behalf of that person, surely that person cannot be made bound by that contract because the person simply wasn't in existence at the time. And even further, the common law position at the time was that even if that principle then comes into existence later, and in this context, as you can imagine, we won't be talking about individual persons, we'll be talking about companies, a corporate person. If it comes into existence after, the common law position was that even that company as principal could not ratify what the agent had purportedly done on its behalf. And that is what you will see in the cases of Kellner and Baxter, Caligara against Satori, Newborn and Sensolid, and all those cases. They all related to what we call in company law pre-incorporation contracts. That is, the people that set up a company had entered into contractual relationships on behalf of that company even before they incorporated it with third parties. And then there was a breach of contract. And then the question arose, is it those agents themselves that will be personally liable under the contract, or the company on whose behalf they made the contract before the company came into existence? So you will see in cases like Kellner and Baxter, where the courts were then looking at how the contract was signed. Was it signed by the agent, suggestive of him intending to be personally liable, or did he execute the contract for the company such that no personal liability was intended to be imposed on the agent? The same thing too in Newborn and Sensory. These are popular English cases that you would again deal with in year 5 in company law. But in any event, at least as regards companies, can you mute, please? As regards companies, the position of the law has changed under Section 96 of the Companies and Allied Matters Act of 2020. And the way that company law has addressed this point is that if a promoter enters into a contract on behalf of a company that is yet to be incorporated, that company, upon incorporation, has the right to ratify. So that was the first sort of displacement of the prior common law position that we see in Kellner and Baxter, Newborn and Sensolid. And the position at common law was that the company cannot, upon incorporation, ratify. That the only thing that can be done is that the new company and the agent and the third party can enter into a new contract on the same terms and conditions as the old contract. But ratification was not possible, was not legally possible because of privity of contract, and the fact that you cannot contractually bind somebody who was not in existence at the time. So that was the first thing that Section 96 of CAMA did. The second thing that Section 96 of CAMA then did, so that there's clarity, and you can see that there is an underpinning policy consideration here of the protection of an innocent third party who has been put into a contractual relationship, and then the fate of that third party is entirely dependent on a question of construction of whether or not a third an agent intended to be personally bound, or he signed on behalf of that non-existent company, and as a result, that company is not bound, and then that's the end of the matter. So the second point that Section 96 dealt with was that in a situation where the company does not ratify that pre-incorporation contract, then that promoter, that so-called agent that acted on behalf of the non-existent company, would be personally liable unless he had expressly excluded his personal liability in that contractual arrangement from the get-go. Other than that, that person would be liable. And then the third requirement of ratification is the fact that the principal must have capacity to do what the agent did. And that you'll have done with Dr. Bayem in terms of the levels of, and even in your law of contract, in terms of who are the persons that have contractual capacity, and the issues around infants and the issues around people of unsound mind and all those things. So the same principles also apply here. Most importantly, in the context of ratification, is that the principal must be aware of all the material facts surrounding the so-called transaction on that principal's behalf, to enable the principal make an informed decision. Make an informed decision whether to ratify or not. And you know, the authorities are clear on the point. Realistically, the principal should be able to ask questions, because if the principal doesn't ask the required questions, and he adopts the transaction, then he is bound by whatever the outcome may be. And lastly, the act to be ratified must be lawful and ratifiable. So, for example, illegal acts are not ratifiable. Void acts cannot be ratified. But also remember in your law of contract that voidable acts can be ratified. Remember the distinction between void and voidable. Void is ab initio void, and no legal rights or anything can even arise from it. But voidable acts are acts that continue to remain valid until set aside by the person in whose favor it has been done. But generally speaking, illegal acts and void acts cannot be ratified, and the authorities are there when you get the materials. And of course, the principal must ratify the whole contract. There cannot be any kind of cherry picking by the principal that, oh no, I don't like this particular clause, I like this one, you know. The principal has to ratify the whole contract, warts and all, as they say. And obviously, ratification must take place within a reasonable time. As I've said earlier, two important points about the effect of ratification. One is that it puts the parties in the position they will have been had the agent been given ex ante authority in the first place. So essentially, it makes the contract as binding on the principal and the third party as if the agent had been properly authorized beforehand. And the effect is that the ratification has retrospective effect back to the time when the agent had acted without authority. So ratification is not that, oh, I have ratified moving forward. It is that I have ratified and going back to when the contract was entered into and going forward, as it were. So that is express agreement, implied agreement, estoppel by ratification. And I think the principles are quite clear. Now, the third instance in which an agency relationship can be created is by estoppel. And in your year 5, you deal with law of evidence, and to a very, very large extent, you would deal with the law of estoppel and the meaning and the instances in which estoppel, the many instances in which estoppel can arise. I mean, we won't talk about all those instances. We just want to focus on this limited instance in which estoppel can be applied in such a way as to create an agency relationship. So estoppel is really a rule of evidence, which just precludes any person from denying the truth of certain matters or the existence of certain facts or circumstances under his control. And most importantly, on the issue of estoppel, is that act from the principal had then been relied on by others, which is the third party, who have then altered their position on the basis of that conduct that they've seen. So on that basis, the principal is then precluded from saying that, oh no, there's no agency relationship. Is there any express agency relationship? So that is the fulcrum of estoppel, is that the courts would look at the conduct of the parties. And if the conduct is such that a person should be precluded from denying the truth that there exists an agency relationship, and that somebody had relied on that set of circumstances in altering their position, then they will be stopped from denying the existence of a relationship. So where a person represents to another as his agent in circumstances in which the third party has relied on the representation, altered this position to his detriment, the person who made the representation will be precluded from turning around to say that, oh no, I mean, there is no express authority here. And as I said earlier, the rule about estoppel applies in so many other contextual circumstances. I mean, and it's just not limited to the law of agency. Of course, as well, given the fact that the law is seeking to recognize contractual obligations on the part of someone who did not expressly authorize another person to act on his behalf. There are strict guardrails that the law has put in place before an agency by estoppel will be said to have arisen. So the first point is that there must be a representation. There must be a representation by the parties. And we have a case of Anyokoya against Olukoya there, where the Supreme Court was essentially restating the common law position. If a person represents or permits it to be represented, that another person has authority to act on his behalf, he will be bound in the same way as he would if the other had in fact authority to act. And then it goes on to say that the foregoing is based on the legal principles of estoppel and holding out, and that there is nothing strange about it in terms of the law imposing that obligation. The second important point is that must have relied on the representation. And if one of these elements is missing, then you can't have agency by representation. And the third one is that there must be an alteration of a party's position. In fact, in some cases, the way that is characterized is that there must be detrimental reliance. Somebody has shifted the third party, because of that representation, has now entered into the contract. And perhaps the contract is one that requires him to have given out money, which is now potentially at risk or in jeopardy. So clearly, in that case, you see that he has relied on the representation and altered his position from someone who would have kept his money in his pocket to somebody who has given out his money to the agent on the basis of the representation. And then I talk generally about the doctrine of estoppel operating in partnerships, how partners in a partnership, for example, are deemed to be each other's agents for contracts made in the ordinary course of the partnership business. So for some of you that are in business and you have partners or friends that you work together, you could potentially be regarded as agents for each other in terms of creating binding legal obligations between your partnership and third parties. So, I mean, agency by estoppel is very, very straightforward. There's really no big issue there. I think the fourth form of creation of agency is agency by operation of law. And as you can imagine, immediately from that characterization, this is clearly a case where agency was not intended either expressly, impliedly, or by conduct resulting in estoppel. But there are instances where, as a matter of policy, the law still imposes that relationship. So the issue of agency by operation of law, I mean, say for example, you have a problem question. Once the question talks about some kind of conduct on the part of the parties or some kind of agreement, then you can't really be talking about agency by operation of law. And under this sort of heading, we have two main forms of agency that can arise by operation of law. Agency of necessity or agency by necessity, and agency presumed from cohabitation. And the first one, necessity, as you would all imagine from the word necessity, circumstances may arise where someone needs to act to preserve the property of another. So obviously there's principles. So we have to situate our minds to the time when, for example, like today, there are no mobile phones. We don't have internet. We don't have 8-lane motorways traveling with speed by train, by air, and all those things. So situate your mind in that situation such that circumstances then arise in which there is an urgent need to preserve somebody's property. And clearly, in such a situation, the person would have acted with no authority to do so. But yet, because there was a situation of extreme urgency, the law then regards what has been done by that person as having been done with the authority of some other person who is the principal, and therefore as that person's agent. And, you know, there are just so many instances in which back then a situation of necessity may apply, but which may not necessarily apply in this day and age. You will see instances in the past where somebody had a serious health problem, and this person took the person to the hospital, and the person was treated, and then the issue arose as to payment of the fees, and the person who was ill that was taken to the place, well, I didn't authorize this person to bring me here for treatment, and so I'm not liable. And then the question will be, but that person, it was a situation of urgency that required them to take you to this place. Now, in this day and age, that's why I said you must put yourself to a situation where it is extremely difficult, if not impossible, to get in touch with somebody whose property is in jeopardy, and then you take steps to protect that property. And then the principal, the person whose property was protected, then wants to turn around and say, well, I didn't authorize you to do it, so why would you incur this expense in saving my property, for example? But as with any other form of agency, particularly the instances in which there is no express authority, the law has to balance as a matter of policy between imposing liability on somebody who has not authorized an agent to act on his behalf, such that the third party is in jeopardy, or a situation where the law actually says that no, in this particular instance, and these are limited instances, we would recognize, despite the absence of authority, we would recognize, given the circumstances, that an agency relationship occurred, so that the third party is protected. The third party who has then performed a service or done something would be protected. So if an agency of necessity is to be inferred or imposed, again, certain conditions must be satisfied. The first one is that there must be a prior contractual relationship. And as you can imagine, this is important to avoid having busybodies who just poke their noses into what is not their concern in the hope that, I can be deemed to be an agent and perhaps I'll be able to earn something from helping somebody and all those kinds of things. So there must be a prior contractual relationship. The agency will typically be readily implied in situation where there is the existence of a prior contractual relationship between the parties. And the act constituting the agency of necessity is just simply a mere extension of that relationship by the agent, who in the unforeseen circumstances that has arisen is compelled to exceed his authority. So, we had talked about a situation where, you might have authority, but you then exceed it because of a situation of necessity. And some of the old cases that you see, for example, the Great Northern Railway against Swafield and the Midland Rail, these are instances in which way back in 1874, 1913, like I said, there was no mobile phone. If your vessel is at sea and the master and the crew find themselves in a situation of grave harm, and then they have to sail into a port, say in Nigeria somewhere, for the vessel to be fixed, and then they incur that liability on behalf of the ship owner. The ship owner has not authorized it, but it was a situation of extreme necessity. There was no way that they could get in touch with the ship owner. But that will not happen in this day and age, because if something happens, there's WhatsApp. Even in the high seas, they have satellite phones that they can use to communicate. Even in the high seas, an email goes in 1 second that you seek approval to incur this expense and all those things. So in this day and age, in my view, these two instances of agency by operation of law, I think that their applicability in this day and age is greatly reduced because of the ability of ease of communication to obtain express authority to do things. And then, like I said, when we get to cohabitation, the current conception about marriage, the current conception about the role of women, both generally, the role and status of women, both generally and within a marriage relationship. And the question will be that, are these instances of relevance in contemporary human relations in the 21st century or even in 2024? Would the instances that occur in Great Northern Railway against Swafield in 1874, if it occurs today, and the master goes ahead and pledges the credit or incurs liability to the tune of 25 million naira, and says, the owner, we had a situation of urgency and we had to do it quickly, and so we incurred this thing, so it must pay. And the owner says, no. Would the courts, even if there existed at the time a situation of urgency, would they still impose an agency of necessity, given the current means of communication that are available to obtain authority? Email, WhatsApp, satellite phone, everything is there. So in my view, the relevance and utility of agency by operation of law in my view, it will be more academic than being something that could still potentially occur in reality. So, I mean, even in those old cases, I mean, apart from cases where prior contractual relationships exist, the doctrine of necessity hardly applies. And so where you gratuitously interfere to protect another's property. For example, a stranger who is not bound by an existing contract with the owner looked after a stray animal. There was no liability to reimburse that stranger by the owner. Because really, the principle is clear. Benefits or burdens cannot be imposed on a person behind his back, and I'm sure that in a Nigerian sense, we have our local sayings about this point that they can't shave your head behind your back. So pretty much that's what the point is there. In that context. And the second important point is the question of an actual or imminent commercial necessity or a genuine emergency to warrant the imposition of an agency. And there I refer to the case of Sachs against Miklos. It's a case that, it's a popular case on this point about agency of necessity. And it's a case that I would urge you to read, even though I'd sort of summarized the facts there a bit, which related to storing somebody's furniture on another person's premises free of charge. The poor guy then needed his space, which was occupied by the furniture. He couldn't communicate with the owner of the furniture. He then goes ahead and he sold the furniture. And the question the court just had to address in terms of whether an agency of necessity arose, which then made the sale of the furniture justified. And the court said, look, they couldn't see any emergency situation in this instance. So unfortunately, the kind guy was then found guilty of conversion for selling the person's furniture, who had left the furniture in his premises free of charge for over 3 years. Maybe there's another moral in that story in terms of helping people, but that's rather unfortunate. Another element is the impossibility or impracticability to communicate with the owner of the goods to get instructions. And you see again that these are all old cases from where these principles have evolved. And I dare say that can we potentially have a situation of impossibility or impracticability of communication? Perhaps, despite the fact that we have all this high-tech means of communication, they still have their drawbacks. So if, for example, and I'm just thinking off the top of my head now, just try to use this analogy to illustrate the point. What if there's a situation of grave emergency that requires an act to be done within 5 minutes? And it so happens that at the time that the owner of the goods they were trying to get in touch with the owner of the goods was inside a lift and there was no reception on his mobile phone. I mean, will that fit this element of impossibility or impracticability of communication. And I make the point just to draw the point that the decision had to be made in 3 minutes or 5 minutes. So it's not a case that, oh, even though there is a situation of emergency, but you could still wait 10 minutes. You could still wait 15 minutes to make that final decision. And it just so happened that the owner was in a lift. Now, it's a different thing if the owner was on a flight from Lagos to London and couldn't be reached on the phone. Even though if you pay for Wi-Fi, you can get Wi-Fi on a flight from Lagos to London. But let's even put that aside. So the person has switched off the phone and they cannot be reached. So the situation or the circumstances of impossibility and impracticability, even though in my view, would be significantly reduced in this day and age, but still there might be unusual circumstances in which there might still be a strong, compelling argument that there was impossibility or impracticability of communication with the owners. Also, another element is that the agent must act bona fide in the interest of all the parties. Again, this is just to eliminate meddlesome interlopers in trying to get themselves recognized as an agent in circumstances in which they ought not to have been. So, but there are, I mean, if you look at the case of Langan against Great Western Railway, again, a very old case, but still, we need to just use it to illustrate the principles. Yeah, and despite the fact that, look, from a policy standpoint, attempts have been made to limit the scope of the doctrine to the instances that we've talked about. There must be a prior contractual relationship. There must be a situation of extreme urgency and necessity, the impossibility and impracticability of reaching the owner for instructions and acting in the best interest. At least in one case, the doctrine had held to arise where a person carried out a moral duty of another. So, a railway inspector took an injured passenger in a railway collision to an inn, which is a sort of hotel at the time. And that person, the railway inspector, was held to be an agent of necessity of the railway company that was responsible or ought to have been responsible for the lodging of that injured passenger. And that was the way that the courts were able to impose liability on the railway company. So the last point about agency by operation of law is an agency relationship presumed from cohabitation. And I think that some of you might be doing family law now in year 3. So, I mean, these are some of the things that you're going to probably deal with, I think. I don't know. But this is one point, or this is one area that I feel that, again, all these cases or this principle evolved at a time when women were regarded. Please, can you mute? Can Olaleye Paul Ayola mute? You are disturbing the class. So as I was saying, it is clear that this principle evolved at a time when, for want of a better way of expressing it, women were regarded as being what is the word now that I can use not to, I mean, just to be brutally frank, that they were lesser than men in terms of anything. They're just, wives who are supposed to be at home, da 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 da. So, because when you see the way that the presumptions evolve here, the law presumes that a woman who cohabits with her husband in their household has implied authority to pledge his credit for necessaries consistent with the kind of life that they live. So it means that the wife doesn't work. The wife is a housewife, and that she's then entitled to do these things. And whether or not we can still have this kind of situation in 2024, I don't know whether, and it's for you guys to answer, whether or not this is, but even at the time, it was just a presumption that could be rebutted. So really, and ultimately, the questions always center around what are the goods that are necessaries and consistent with the kind of life that they lead. But almost immediately, you see that the circumstances in which an agency of necessity would be implied for the wife of a farmer is different from the circumstances in which an agency of necessity would be implied in the context of the wife of the MD of a bank, for example. Because the question of the necessaries, the goods that are necessaries, is dependent on the husband's style of living, the way and manner in which they've led their lives. Is it a flamboyant kind of lifestyle, or is it a frugal kind of lifestyle? And look at what somebody said in 1870. What the law does infer is that the wife has authority to contract for things that are necessary and suitable to the style in which the husband chooses to live, insofar as the articles fall fairly within the domestic department, which is ordinarily confided to the management of the wife. I'm sure that quite a number of especially women, will find these statements in itself condescending, but that was the situation at the time. We're talking about 1870, so I don't think anybody should be offended. But the question is that, will these principles, do they continue to have relevance? Should they continue to just be there in the books just for contextual understanding? Or could there still be limited instances in which these principles will still apply? And I would imagine that it will still apply, say particularly for the uneducated and illiterate, maybe, but certainly for educated folk, would a wife still want to, in certain circumstances, pledge the credit of the husband for necessaries? So what are these necessaries? I mean, generally speaking, they include clothing, both for the wife and the children, articles of household equipment, food, medicines, medical assistance. And depending on the kind of lifestyle that they live, it might also include the hiring of servants, which will not be considered as unreasonable in certain circumstances. But if the wife orders things of an extravagant nature or excessive in quantity and are not consistent with the husband's style of living, then there will be no presumption. And no action can be maintained against the husband. And the reason why this is the case is because the third party wants to impose liability on the husband because he is the one that has the money. He can sue the wife, but the wife doesn't have any money in the first place. So that is why this point is even important, because if the husband is not liable, then that third party, in all probability, would have lost the money. And again, like I said, this would depend on the particular circumstances. So if, for example, we're talking about the wife and children of, let's say, a farmer in the village, and the wife then decides to pledge the credit of the husband, and then buys clothing from the top shop in Ikeja City Mall, fabric of 100,000 naira or 200,000 naira as clothes. You can see the disconnect without necessarily trying to put down farmers. Farmers are also rich people, but just to illustrate that what the law is trying to do here is to look at the style of living of the husband and whether the demand for the necessaries of the wife is consistent with that kind of living that the husband has engaged in. So there are requirements for cohabitation, as usual. Again, I mean, all these things are just trying to put guardrails so that where you have a principle that is intended to protect a particular class, it is not also abused by that class to the detriment of third parties. So it's always a nice balancing act that the law is trying to do here in terms of imposing this. So for example, there must be cohabitation. Husband and wife are living together, and in such circumstance that it would be reasonable to infer that the wife is acting on behalf of the husband when she orders the necessaries. Now, one thing that seems to be interesting here is that marriage is not necessarily a prerequisite for this, because and again, because it's evolved in England, you know. So for example, in England, and I don't think that the position has changed now, but if a man and a woman live together in the same house, under the same roof for a period of 6 months or more, then the lady is regarded as a common law wife. Okay, so which might explain why this principle has evolved in this sense that marriage is not a prerequisite for the requirements of cohabitation. For as long as they are living together, So for example, the presumption applies in the case of a woman living with a man as his mistress at the time. So as long as there's cohabitation, then the woman will be deemed to be in the position of the wife. Now, but if the couple are separated, then prima facie, the wife no longer has the authority to pledge the credits and create an agency relationship between the husband and a third party. So you have to bear that in mind, that it is just a presumption, because there are times where there's a separation, but there's still some kind of ongoing obligation on the part of the husband until divorce, because we're talking about separation, but not yet divorce. And you can see that where the parties are then separated as a result of a court order, that is, there is divorce, maybe there's been dissolution of the marriage, then the husband is no longer liable for necessary supplies to the wife. She can't even pledge his credit for as long as he continues to comply with the obligations. Also, importantly, there must be a domestic establishment. Can you please go on mute, please? There must be a domestic employment establishment. Somebody is disturbing the class. Anyway, so what do we mean by domestic establishment? The simple fact that a man and woman live together as husband and wife is not sufficient. There must be evidence that they live as a family. They must show that they are a family. And the case of Debenham against Mellon just sort of illustrates the point, where the husband and wife were actually living in the same abode because of work. Rather than the fact that they were living in the place as a family. And then we've talked about the goods must be necessaries. So instances in which the wife clearly cannot exercise any authority on behalf of the government of the husband, even where the goods are undoubtedly necessary, the husband can still, even though he's presumptively liable, he can rebut that presumption by establishing a number of things. The first thing is that he can establish that the goods were supplied exclusively on the wife's credit. So if the wife is working or whatever, he can make that argument. Where there is express notice to the particular trader not to supply goods to the wife on the husband's credit, then the husband can get away with it. Or where the wife has been forbidden to pledge his credit, whether or not the supplier knew of this. And this could potentially be a contentious point, because if the husband had held out in the past that she could pledge his credit, then there can now be an issue of estoppel that will preclude the husband from disproving our authority. So, I mean, if the goods are necessaries, but they are excessive and extravagant, having regard to the husband's income. So, ordinarily, they will eat pap without milk and honey. But she then decides that, in fact, there's this pap that has a strawberry flavor, and there's this honey that they say is the best thing since sliced bread, and then she pledges on that basis. I mean, the husband can easily, say that, look, this is excessive and extravagant and beyond the way I've lived my life. And then if there's evidence that the wife has already been supplied with sufficient articles of that kind, or is given or has been given sufficient allowance with which to purchase the goods. So the last point, and look at this case, is a 1952 case. And the question now is the wife's independence means relevant? So if you now have a wife who is working, and there are instances in which even the wife earns more than the husband, would this principle of agency by operation of law be applied? And listen to what Lord Denning says in Bieberfield against Behrens. He essentially sort of suggested a means test to be applied. And the reasoning is that it must follow from the modern equality of sexes that the wife, if she can afford it, must help in discharging the household accounts. And that a wife who is well off is not entitled to spend all her money on luxuries and throw all domestic liability on the shoulders of the husband. That's an interesting thought I'll leave you with. Thank you very much. Any questions?
Hello, good morning, sir. Hello, good morning, sir.
Good morning. Good morning.
Yes, sir, please. I didn't get the differences we made between estoppel and implied agreement.
Okay. Again, in the context of implied agreement, there is either an express agreement that does not cover or deal with all the issues within the agency relationship, particularly on the issue of authority of the agent. And so there would be instances in which the court would imply an additional agency relationship, maybe beyond what was expressly said, because the parties just didn't realize that they needed to put that point in together with the express provisions. But in the case of estoppel, there was no prior authority in the first place. But the courts look at the conduct of the principal. And if the conduct of the principal is suggestive or indicative that an agency relationship should exist or is in existence, the courts would say that the principal is stopped from denying that there is, in fact, an agency relationship. So that's this sort of slight nuance between the implied and the estoppel thing. The estoppel thing is a question of looking at the conduct of the agency and the detrimental reliance of a third party as the basis of imposing an agency relationship in those particular circumstances. Next person, either Grace or Habib.
Sir, good morning, sir.
Good morning.
My question, not really a question. I think based on what you explained so far, I have like higher level understanding all other ways of creating an agency relationship, but the aspect of ratification. So I would just like to shed more light. Thank you.
You said, I didn't get what the question was or your last comment.
I'm basically asking that you give some more clarity to agency created by ratification, sir. Thank you.
Okay. Again, just like I just said earlier, in the case of agency by ratification, somebody has purported to act on behalf of the principal with zero authority. Okay? Either because the principal was not in existence or the principal was just simple. But later on, after the agent has entered into that contract with a third party, either before or, well, usually it will be before. And then after that fact, the agent then brings it to the knowledge of the principal that he had purported to do X, Y, Z on behalf of the principal. And if he lays all the material facts before that principal, and the principal, and then all the other elements are met. The principal has capacity, the principal was in existence, If all those elements are met, and then the principal says, well, despite the fact that I did not give you authority to do this thing on my behalf, but now that I have the full facts, I would adopt the transaction. I would adopt and ratify the transaction. So if, for example, that person had entered into the contract purportedly on behalf of the principal in June of this year, and it is only in December that the principal is made aware and he decides to ratify. As I said, if he ratifies today, it means that the authority and his own being bound, the principal being bound by the agreement, now starts from June when the agent had signed the contract, even though the ratification is in December. So it's not a question that, oh, the ratification was done in December, and then December moving on is when the principal will be liable. And maybe there has been some obligation that is extant to the third party between June and December. And he says, no, I don't have anything to do with that period. No, once you ratify, it relates back to when the contract was signed. And the principal will be bound from that point on. Okay?
Okay, so thank you very much, sir. So you're trying to, sorry, sir, you're trying to say that what's it called? For such a relationship, an agency relationship to be successfully ratified or should be to be valid, all the facts prior to the ratification must be presented to the principal.
Absolutely. The principal must ask those questions and get a clear understanding. And once he does that and he ratifies, then he's bound. And remember that he's not legally bound to adopt. So if he refuses to adopt, then the question will typically be, can that third party find something by which he can then impose personal liability on that agent that acted without authority? And if the agent is a man of straw, then the third party has lost. So you can see the balancing act that I always talk about between the interest of a principal who did not give authority and a third party who has acted genuinely with the agent who has no authority. I think it was Grace that put her hand up first. We are 11:05. I don't know whether there's any other class, but go ahead.
Okay, good morning, sir.
Good morning.
My question has to do with estoppel. So from what I understood from the class, okay, now just go to my question. My question is, in estoppel, whose representation matters? Is it the representation of the principal or the representation of the agent? And if it's the representation of the principal that matters, does it mean in a situation where an agent goes about representing that he is an agent of the principal, it can be classified as unsolicited help? That's my question, sir.
Okay, the answer to your first part is that it is the representation of the principal that matters, not the representation of the agent. It is the representation either expressed or by conduct, the way and manner in which the principal is relating with that agent, which is suggestive to a third party that there is an agency relationship between them. So the key relationship, the key representation, or the key conduct in the context of estoppel is the act of the principal. Okay?
Okay, sir. Thank you. So, in that case, if an agent is the one going about making this representation, it should just qualify as unsolicited help.
I mean, absolutely, he's acting without authority. He's acting without authority. And the question would be, like I made the point earlier, whether the third party can then go against that agent personally, you know, because you know that one of the points about ratification is that the agent must have purported to be acting as an agent. So in all probability, it might be difficult for that third party to impose personal liability on the agent if the agent was just the one that was saying, "Oh, I have the authority of the principal." It is the conduct of the principal that the third party must first of all look at first, because it is that conduct that would make them that they've relied on to their detriment in entering into the contractual relationship with the unauthorized agent.
Okay, thank you, sir.
Any other questions?
Yeah, Elusa, my last question, please. So my question is on ratification. Peradventure, an agent maybe he has already gone through the whole authorities and he has started the contract even before the principal gave him capacity to do it. And you said in ratification that it's the principal that should ask the questions in order to be aware of whether or not he wants to ratify. So in a situation whereby the principal probably negligently do not ask the necessary questions or is unaware of some certain facts of the contract and then goes ahead to ratify it, is there a space for him to rebuke the contract in the future due on that grounds that he was unable to know this?
No, because like you rightly said, he was negligent in not asking the right questions to get the material facts. So the assumption would be that he had full knowledge of the material facts and the ratification would be valid. And I think there's even an authority. I think there's an authority on that point.
All right, thank you, sir.
Okay, then, I mean, this is 10 past 11. We'll continue on Monday at 11 o'clock. Thank you very much, everybody.
Thank you very much, sir.